Hello, and welcome to the NAMI 2020 Virtual Annual Conference. I am here with Jen Longton and with Kate Power, and we will be presenting to you today on issues with incompetence to proceed and the mental health system and where they begin to overlap, and we can see potential light for the people that we are caring for. I would like to start, however, by a small introduction here with Jen Longton. Jen Longton is the vice president of the board at NAMI Colorado, and she is also principal at her law firm running a mental health a mental health criminal defense law firm. And I would also like to introduce to you Kate Power, who is joining us today. She is the county attorney, assistant county attorney in Boulder, and she is in charge of involuntary mental health certifications and other court orders that go attendant with those cases. And there will be a moment where they can each tell you a little bit more about themselves and their work. As I begin to share my screen, there might be a moment here of some space, so just bear with me while I pull up our slides for today.
And actually, I'm going to introduce our other presenter, Jonathan Colwell, who has been talking to you. And Jonathan is also on the board of NAMI Colorado, and he is a probate attorney who works in guardianship and court-appointed counsel in mental health-related cases in town. So thank you, everyone, for being here. Oh, there we go.
That was perfect timing.
So we are here to talk about incompetence to proceed in the criminal court system and how that transitions sometimes, not always, into the civil mental health system. If you could put the next slide up, Jonathan. So what does incompetent to proceed mean? It means that a defendant in a criminal case, that's number one. So you're in a criminal case, you are the defendant, and you have a mental disease or defect, which could be a lot of different things. Schizophrenia, bipolar disorder, it could also be PTSD, it could be a brain injury, it could be an intellectual disability. Those, basically, once you have that mental disease or defect, what incompetent to proceed means is that that mental disease or defect is preventing you from doing two things in the courtroom. One is understanding the proceedings that are going around you. Like, what does a judge do? Should I talk to the prosecutor or not? Do I have a right to testify? It could also be preventing you from effectively communicating with your attorney to further your defense. It could do one, it could do the other, or it could do both, but as long as it does one, it means that you're incompetent to proceed. Now, if the state proceeds to put you on trial, that's a due process violation under the Constitution. It means that we've decided as a society that we're not going to put people on trial who can't understand what's going on around them and can't defend themselves. If you could go to the next one. So once you're found incompetent to proceed in a case, sometimes you can get restored through mental health treatment or education on the court system, but sometimes you're an individual that is not likely to be restored, or also sometimes referred to as permanently incompetent to proceed. After the court spends some time trying to restore you, and it's not working, and the doctor says, you know, this isn't going to happen within a reasonable time. And it depends on what you're charged with in the case as to what a reasonable time is. The way the statute calculates it is half of the maximum amount of time you could be put in jail on the top count. So if you're charged with a third-degree misdemeanor, which is punishable by up to 6 months, they can hold you for 3 months. If you are charged with murder, which has an indefinite life sentence, they can try to restore you for the foreseeable future. But once we find out that you're not likely to be restored, then the court and the defense start to figure out how to dismiss the case for incompetency. When someone meets civil standards and their case is being dismissed for incompetency, the criminal statutes have kind of a backdoor way of kicking the case to the civil arena. And that's by saying if the person qualifies as intellectually disabled or as mentally ill under 65 or Title 27, then the city attorney, the court can ask the county or city attorney of the jurisdiction to initiate civil procedures. Can I have the next slide? And you can skip this one and go to the next one, because I'm just going to talk a little bit about what you should be seeing in a competency evaluation for maybe a loved one, or if you're an attorney and you're looking at these kind of cases. The competency evaluations during the restoration process need to include a diagnosis and a prognosis, because if we don't know what the diagnosis is or what the prognosis of restoration is, then the court can't figure out whether to dismiss the case or not. Then the evaluator also has to talk about whether or not the person can be restored in the foreseeable future, and a recommendation for either inpatient treatment or outpatient treatment as part of the statute. So next slide, please. We finally get to a finding of unlikely to be restored or permanent incompetence to proceed. It's usually called unlikely to be restored now. Permanent incompetence is kind of the old language. Next slide. And here's that transitional language. We can stay the court can stay the dismissal of the case for 21 days in order for the county attorney to initiate those civil proceedings. However, and this is a big however, just because someone's incompetent to proceed does not mean that they meet the civil standard for commitment or treatment. A person has to meet that civil standard in order for the civil arena to be able to take over the case. If they don't, and they're not an immediate danger to self or others or gravely disabled, then the case gets dismissed and the person is done with their case and hopefully receiving some sort of services. Sometimes that's arranged through the state hospital or local mental health providers. But at this point, it tosses over to the civil arena. So I will turn it over to Kate.
Thanks, Jen. So as Jonathan said, my name is Kate Power, and I'm one of the assistant county attorneys for Boulder County, who handles the mental health caseload for the county. I've been with the county for, I'm in my 5th year as an attorney, and previously I was with the county as a court liaison, which was kind of like a law clerk position. My current caseload includes mental health cases, child support cases, child protection cases, and public benefits investigations and recovery. So it's all really in that human resources world, or human services realm. And as far as the mental health caseload goes, our county sees every year between 500 and 650 mental health cases. These aren't all contested cases. This just means that we see between 500 and 650 cases that come through on a certification. So people who have been certified to the civil commitment process. In my time with the county, I've done, I think, a rough estimate between 70 and 80 contested hearings. And then I have done 4 successful briefs to the Court of Appeals after those hearings, after the results of those hearings were appealed. So I just wanted to give you a little perspective where I was coming from. And before I jump into exactly what the process is, I wanted to go over a couple of key terms that I think I have a tendency to throw out there because I use them in everyday language, but other people might not know what they are. So I think the next slide starts with gravely disabled, and so we'll start there. So one of the key terms that I want to make sure we go over is gravely disabled or grave disability. And what this means is it's a legal designation that the law has for someone who, as a result of their mental health disorder, is unable to care for themselves without significant assistance from other people. So this means, you know, a person has a mental health disorder and they can't find a home because of it, or they can't get a job or understand how to feed themselves or take care of their concurrent physical conditions because of their mental health disorder. Another key term is danger to self, and the law defines this term as someone who, as a result of their mental health disorder, poses a risk of harm to themselves, either by recent physical threats of suicide or recent threats of suicide or recent acts of violence against themselves. The next term is danger to others, and danger to others is a term that's used to describe someone who has a mental health disorder who poses a risk of harm to other people because of violent acts they've committed or threats of violent acts that have put other people in reasonable fear. You know, those violent threats were credible. Next slide. So, and then certification is a big one. And that's really just when we talk about when a person is placed under the care of a mental health facility for treatment of their mental health disorder. It's the legal process by which that is done. A mental health evaluation is another term that I wanted to make sure we touched on, and that's an evaluation conducted by a professional person that determines if a person needs to be certified for further mental health treatment. And lastly, who is a professional person? That's a person who's licensed to practice medicine in Colorado or a psychologist certified to practice in Colorado. There are also some other provisions in the statute for professionals licensed out of state, but those, I don't see those in practice very often, and so we can move forward without discussing those in detail. So what is a civil commitment? So a civil commitment is the legal process by which a person is placed under the care of a facility that is designated by the state of Colorado for the treatment of mental health. A civil commitment can be for inpatient treatment. That means someone goes to a hospital, stays there overnight, lives there for a time. It can be outpatient treatment, which means that someone is under a certification to work with a facility and they go and they get monthly treatment. It could be like a monthly medication or a monthly appointment, a monthly check-in, something like that. And civil commitments can also include involuntary medication, which is a court order that sometimes doctors get in order to provide medication to someone who is on a certification who may not otherwise agree to treatment. So there is kind of a linear process when we talk about how someone gets into the mental health system via a civil commitment and what happens while they're in it. And so when I handle cases, they always start with a mental health evaluation, which is that evaluation done by a professional person. It can result in a certification, which is that civil commitment where someone is placed in a hospital or on outpatient treatment. And we'll talk more about what certifications are, but they can be for a short period of time, they can be for a longer period of time. And then once someone is certified, there can be involuntary medication if there's an additional court order. And then if someone contests that medication or the certification, then we'll go to hearing and the person will have an opportunity to say, hey, I don't want this. This is why I don't want it. So evaluation, certification, medication, hearing is really the process that we see these things come through. So to start with, let's talk about the mental health evaluation, which is the first piece. So a mental health evaluation can occur in a couple of different ways. The first way is by an emergency procedure. And essentially what that is, it gives professional people like doctors or peace officers, police officers, the authority to take somebody to a hospital if it appears the person has a mental health disorder, and because of that mental health disorder is an imminent danger to themselves, to other people's, or gravely disabled. So, you know, if police were to interact with a person who in public who may be threatening other people or appeared to be, to really be sick and not be aware of what they were doing, then the police have the authority to effectuate this emergency procedure, bring this person to the hospital so they can get a mental health evaluation and get the help they need. There's also another way to get an emergency mental health evaluation done, which involves a person going before a judge and affirming or swearing that a person is an imminent danger to themselves or other people because of a mental health disorder. I don't see that a lot. Every jurisdiction is different, so it might happen a lot in other jurisdictions, but usually we see our emergency mental health evaluations come through from police officers interacting with people who need the assistance. Next slide, please. So in addition to the emergency procedure for mental health evaluations, there can also be a court order for a mental health evaluation. And this allows for anybody, and in our jurisdiction, we usually see family members or friends, anybody can ask the court or petition the court to say that, hey, I know somebody who I believe they have a mental health disorder and they appear to me to be dangerous to themselves, to other people, or to be gravely disabled. And so a petition is essentially a statement affirmed and filed with the court, so the court can review it and say, okay, it looks like maybe there should be a mental health evaluation in this case. On review of the petition, the court is to order a screening by a professional person, so a licensed doctor or psychologist in Colorado, to review the case and see if the petition is credible. And then following that screening, the court may order a mental health evaluation and order the police to go and actually take that person and bring them to a hospital. So the difference between the emergency procedure and the court-ordered procedure is really how quickly it pans out. So emergency procedure, a police officer can take someone into custody immediately and bring them to the hospital. Under the court-ordered procedure, there is this process by which you have to file with the court has to order it and get an order for the police to go and get this person and bring them to the hospital for the evaluation. So if there is a mental health evaluation, either via the emergency procedure or the court-ordered procedure, the person subject to that evaluation is brought to a facility so the evaluation can be conducted. This can be an emergency room or a hospital, and under an evaluation, the person can be kept there for up to 72 hours. So the key there is that it may actually be less if the evaluation occurs within that 72 hours, but the law allows for facilities to hold people on an evaluation for up to 72 hours. Once the evaluation is conducted, the patient or the person is either discharged because the doctor has determined they do not need additional hospitalization, they don't need the civil commitment. They could be admitted for voluntary treatment if the person after the evaluation says, okay, you know what, things haven't been good, I do need help. There can be voluntary treatment available. Or if the doctor or the professional person believes that the patient is in need of additional mental health treatment and the patient is not agreeable, then the person can be certified for short-term treatment. So what happens when a certification occurs? So if a person receives an evaluation, they may be certified for the short-term treatment. And a doctor needs to consider certain criteria to ensure that someone meets the legal standard for a certification. So that criteria is that the evaluation shows that the patient has a mental health disorder, and because of that mental health disorder is gravely disabled, a danger to themselves or a danger to other people. The doctor also needs to show that the patient has been advised of but rejected voluntary treatment or reasonable grounds to exist to believe that the person will reject the treatment. So this could be somebody who initially accepted voluntary treatment but then decided, no, I don't want it, and the doctor thinks, well, you know, you do need it. So that can be grounds for certification. The facility at which another piece of the criteria is that the facility at which the person will receive treatment has been designated by the state of Colorado to provide mental health treatment. So certifications can only occur at these facilities. They can't occur at just a general facility that hasn't received a designation. And once the certification is initiated, the facility must file notice of that certification with the appropriate court. So when a certification begins, it always begins as a short-term certification. And a short-term certification is 3 months or less. So someone can be certified for up to 3 months on a short-term certification. However, if the person improves, or if you improve before that 3 months is up, then the patient or you can be discharged from the facility. Certifications can only occur if those criteria that I listed in the previous slide continue to be met during the certification. So it can be up to 3 months, it can be less than 3 months. If a patient needs more than the 3 months treatment, the facility is required to file, it's essentially a renewal, but it's called an extended short-term certification, which is 3 additional months, up to 3 additional months. It could be shorter. If additional treatment is needed after that, a long-term certification would be filed for an additional 6 months. And then if more treatment was needed, then an extended long-term certification would be filed, which is 6 more additional months. Certifications can be, like I said, on an inpatient or an outpatient basis. So a lot of times you might see a short-term certification that starts as inpatient and is transferred to an outpatient facility if you or the patient doesn't need the structure an inpatient facility would provide. So certifications can be transferred between facilities. For example, in Boulder County, a lot of times we see short-term certifications start at an inpatient facility like Centennial Peaks, and then there's improvement, and then the certification can be transferred on an outpatient basis to a facility like Mental Health Partners. The law does require that at any moment, if those certification criteria no longer exist, the patient must be discharged. So if, even if a patient still has a mental health disorder, if they're no longer gravely disabled, then the certification must be dismissed. Next slide, please. Oh, okay, great. So something important to know is that certifications alone do not provide doctors the authority to administer medications against a patient's will. So you can be certified, a patient can be certified, and if you don't want to take medication, the doctor needs an additional court order in order to administer that medication to you or to the patient. So typically when this happens, a patient will be on a certification, and then the doctor may request directly to the court a letter saying, I would like to see some involuntary medication orders for the following reasons. And the doctor has to provide the basis to the court for his involuntary medication request. Typically what you see with these requests are the diagnosis, the mental health diagnosis, the symptoms that come from the mental health diagnosis, why you or the patient is refusing the medication, and the specific medications the doctor is requesting and why they want those medications. A lot of times too, you'll see the doctors list the potential side effects and the potential benefits to each of the medications requested in their letter. Next slide, please. So a patient has the right to contest treatment, both the certification and the involuntary medication. So whenever a certification occurs, whoever is certified is appointed counsel by the court, and the court will pay for it if the patient or the person does not have the money to pay for counsel. So every time a certification happens, there's an automatic appointment of counsel, which I believe is what Jonathan does.
That is correct.
Yeah. So Jonathan and the other respondent counsel, and in my jurisdiction, and I'm assuming in other jurisdictions, I think very highly of the respondent counsel. They're all really, really wonderful attorneys. So respondent counsel represents the patient, and then the statute says it's either the county attorney or the district attorney's office, depending on the size of the county, are the ones who represent the people. And the people are the ones who are bringing the action for the involuntary medication and the certification. So that's where I come in. I represent the people, and we'll work the case with the doctor. And the hope is you can get an agreement between the patient. I also said respondent. Respondent is the patient in these cases. And the doctor. Sometimes that means, limiting the medications, deciding on some different medications. So we try to reach an agreement where everybody is happy, but if we can't, then that's when we go to a hearing. So the court hearing piece, that's the 70 to 80 cases that I think I've done. That's a rough estimate, but that's when we can't reach an agreement on these involuntary medications or the certification. And so we have to go to court and have the court decide if the certification and the involuntary medications are warranted. And so what happens at those hearings is that typically what I do is I have the doctor testify about why the certification and the medications are necessary in the patient's case. Occasionally, family members can testify. I don't personally like doing that. I think it can be a really difficult thing for family members or loved ones to testify against someone in these circumstances, which are very difficult, but that can happen. The patient or respondent is represented by counsel and absolutely has the opportunity to testify and cross-examine the witnesses. So you can ask the patient can ask the doctor questions, all the questions that they want. And just an not interesting, but a note that right now, all of these hearings are remote because of the pandemic restrictions in Boulder County, unless a patient or respondent requests the hearing in person. And I'm not sure if Jen or Jonathan, you can speak to your jurisdictions if these are remote or not.
At this point, Jefferson County is requiring a motion for them to remain electronic, but otherwise you do have to appear at the court. And in Denver, I believe that is the same situation, that they have also moved to in-person hearings again.
Interesting. So Boulder, and we're recording this on the middle of October, and I haven't heard that this is going to change anytime soon. So we might be in the minority here, but okay. Next slide, please. So what happens at the court hearings is that after all the testimony and any other evidence has been admitted to court, the court must make a finding by clear and convincing evidence, which essentially just means that the court needs to find that the people and the doctor and the hospital have made their case to the extent that it's free from substantial doubt. And to uphold a certification, the court must find that the patient or you have a mental health disorder. As a result, there's the grave disability or danger to selves or others, that voluntary treatment has either been rejected or that reasonable grounds exist to believe that a person will not stay in treatment, and that the facility providing the mental health treatment is designated by the state to do so. And for the medications, the court may order the involuntary administration of medications against someone's wishes under the following circumstances, which is by case law here in Colorado. And they must find, in order to make the order that involuntary medication should be administered, the court has to find that the patient is incompetent to effectively participate in treatment decisions, that treatment by medication is necessary to prevent a significant and likely long-term deterioration in mental health, or the likelihood that somebody might cause serious harms to themselves or other people, that there's no less intrusive treatment alternative available. And that essentially means a treatment that is just as effective as the one that is requested by the doctor. And then the patient's need for medication is sufficiently compelling to override any bona fide legitimate interest the patient has in refusing treatment. And, oh, we came to this slide much more quickly than I thought. So something else I did want to touch on, which is much less common in the hearings we see is electroconvulsive therapy. It is something that the courts can order. There's case law and statute around this, but I would say I maybe see one of these cases, I see them maybe once a year, as opposed to other cases where I see dozens of cases for involuntary medications aside from the ECT. And that, I think, was the quick overview. I think that's the end of my slides. That's the overview of the certification and involuntary medication process from my perspective.
No, that was great, Kate. I did double check there for a minute on our slides to make sure I haven't clicked forward too quickly.
Perfect timing.
But no, very enlightening. So then to skip forward to some different perspectives on this, Jen, you're probably okay if I jump in for a few minutes here on this right now?
Oh yeah, go for it.
So,
I'm happy to answer any questions.
no, it's interesting, you know, as respondents counsel and as someone who's been really interested in the confluence of these two areas of law since the new statute came out, listening to someone else's perspective, listening to Ms. Powers' perspective here, and learning from that, and realizing in my mind that the biggest question for me leaving the two different areas of law, the two different presentations, is that there's two different evaluations required by statute for the exact same thing, and they're kind of really at the exact same moment. Legally speaking, not in the person's life, but that if a person has been found incompetent to proceed, and as Jen said, the new language is unlikely to be restored in the foreseeable future, there's two different statutes that might apply to having that moved over to the criminal or to the mental health side of the law. One of which, I should say both of which are under Article 8.5 of Title 16, and they reference that proceedings may be initiated under Article 65 of Title 27. And then they also authorize the court through statute to, let's just say, work with the attorney for the county or the attorney that's appropriately supposed to represent the people in petitions for involuntary mental health. And one of the issues, and Kate, correct me if you've heard something more on this or there's been some development in Boulder County, but that what I've run into in a few different jurisdictions is that the criminal court isn't comfortable appointing a county attorney for a civil matter. And so it's kind of a situation where you are, where at least where I have tried to make things easier on clerks and on the court and on whoever else is involved, and trying to encourage the initiation of mental health proceedings. Notice too, again, the second evaluation that I was talking about is that in order for someone to be certified for involuntary treatment, they must have under 2765-107 been evaluated pursuant to either 2765-105, which is where Kate was describing the emergency procedures, or under 2765-106, where Kate was describing a court process in a non-emergency basis. And so what's fascinating to me as an attorney is how do we get the professional evaluation that's required at the, here, I'll go reverse for you guys, right to left, right? How do we get the part of the evaluation that's required for determining that they're unlikely to proceed and includes whether they qualify for inpatient involuntary treatment, to communicate with the side that requires that evaluation prior to a up to 3-month commitment. So that's one of the pieces there. And then Jen, can you comment on any of that at all?
If I unmute myself, yeah. I mean, I think that the biggest struggle that I see with any sort of transition from the criminal system to the civil system is, first of all, the world that Jonathan and Kate work in is very sealed off. It is incredibly private and protected to the extent that a criminal judge cannot look up a probate case that is going on in the mental health court. So even if it's the same individual and it's sprung from actions that happen in the criminal case, we can't see any of it. So it's often the responsibility of defense counsel and respondents counsel to kind of work together and figure out exactly what is going on in the situation. I think another struggle is the courts will do things like order the county attorney to civilly commit an individual, and Kate can't do that. Like we said before, an individual has to meet the standard of imminent self-harm or harm to others or gravely disabled. And that's not always going to be the case. There are many people who are incompetent to proceed in a criminal case that are completely not able to be certified under the civil standards. So that transition really only happens in extreme cases in the criminal system. But I think it's also something that is important to look at, because often, my example before with a murder case, if you had a psychotic break and unfortunately killed someone and you're still not competent and there's no restoration that looks like it's going to happen, district attorneys are really loath to dismiss those cases for competency. But if it's a situation where they have a pretty good feeling that the person is going to go into the civil system and continue to receive care once they're out of the state hospital, sometimes it makes it a little easier to have the state agree to that sort of dismissal transition. Because my biggest thing is I want the criminal case gone. Criminal cases can really interfere with someone's life, their treatment, their care, where they can live, who they can see. And once a person moves out of the criminal system into the civil system, things are far more private. They still have appointed counsel, and the standards are a little different. And I know from the perspective of individuals who have been civilly committed before, it's still not from the inside a friendlier system sometimes. But legally, I think it is one that is far better suited, obviously, to medical treatment for someone than the criminal justice system, which is not at all suited to medical treatment for anyone, even though that's what we have them do. So those would be kind of my little additions. I don't know if you guys have any other questions from a criminal side, but.
Well, tell me a little bit about, and I know we're not doing a not guilty by reason of insanity presentation, but tell me, if someone were to have a case dismissed based on a pleading of not guilty by reason of insanity, are they then, do they become a ward of the state or something like that?
They do. They're committed for a day to life, so indefinitely, to the care and custody of the Department of Human Services. But they are not in the same system as someone who was, say, put on a 72-hour hold and then initiated into a long-term or short-term certification. The individuals who plead not guilty by reason of insanity start out living at the state hospital down in Pueblo in the forensic unit. And what forensic psychology, or anytime you hear the word forensic in relation to mental health, it means where mental health intersects the criminal justice system. So the forensic aspects of treatment are handled down at the state hospital, and then individuals can progress to community release. And there actually is going to be a presentation up where Bill Martinez and I talk about this if you're interested. I believe it's on the Saturday of the conference. But it is not the same system. And if a person who is on community release has a medical episode that requires hospitalization, they may be brought into an emergency room locally for the short term, but instead of progressing into the civil system, they are regressed back to the state hospital in the forensic system there to the people who have been rendering care for quite some time.
Yeah, thanks. That's really helpful. I think I think the reason that comes up for me is because when we as attorneys are looking at our cases and whether our case might, as a private attorney, I certainly do this. What would the judge say when I bring this petition or a motion, or I want the judge to make an order? I have to look at it from that judge's perspective, and the judge is often in the place of ensuring public safety. And so
Yes.
if a person is committed from one day to a life indefinitely until they are qualified for release because they become safe again, versus that the case has to be dismissed because they're incompetent to proceed. A judge is pretty uncomfortable in general with saying, okay, well, I guess you get to go free now. And so this system is designed, well, this I should say this system is intended to
They're
provide
trying.
an additional layer of safety. It's in flux. We are working on it as individual private attorneys as best we can. And certainly the state is making strides toward changing our system as well.
The
So
competency standards change. Well, not the standard for competency that is under United States Supreme Court case law, but the laws around competency changed a couple years ago. It used to be that they could hold you as long as the top count. Now they can hold you for half of that, which is a huge difference. And it also has more exit ramps along the way where cases can be dismissed. But again, back to what Jonathan is saying, it is a hard ask sometimes, and that's why the statute is so clear that the court at a certain point must dismiss the case, because judges are very risk adverse and they do get concerned about community safety. And I think we also have a belief in our society that even though we don't think people should be prosecuted if they're incompetent or convicted if they were insane at the moment of the crime, we still have a struggle with that because we like culpability and we want someone to be guilty. And that is a struggle. I think this is a way to give the judge a little more comfort on extreme cases. I think the state still has a ways to go with making sure that individuals whose cases are dismissed for competency that do not qualify for any sort of civil proceedings still get services when they're cut loose. Because I'll tell you anecdotally, I had a client who was released after his case was dismissed because he was permanently incompetent to proceed from mental health issues and developmental issues. They let him out of the jail. This was not downtown. This was in a more rural area at about, I think, 2:00 in the morning with a bus pass. And that was the end of his care. And he had been inpatient in one of the jail-based restoration programs for over, I believe, 2 years at this point. And so that is a huge problem still, is not the cases that transfer to Jonathan and Kate's arena, but the cases that don't, and what we can do to make sure that those people aren't just cut loose with no services, and that they have access to mental health care and they have access to caseworkers if they need it and they have access to housing.
hey, Kate, a little bit of a hot seat here. I wonder if you have any opinion on criminal courts calling you up and saying, hey, why don't you take this case?
That is a hot seat. And I don't have an opinion at this point, but thank you for giving me the opportunity to provide one.
Oh, you sure? No problem. Yeah, I just didn't know if maybe there was something there, but I know that for me, I haven't yet found a way to motion that or to make it happen legally. And so, that's one of my concerns. One of my other major concerns is that many of us, I think, watching here might be familiar with the fact that the civil mental health system is a structural framework. And what I mean by that is that the first, an easy way to see it, the first thing that happens is a 72-hour hold, and you don't have to be held for 72 hours. And the next one's a 3-month certification, and you don't have to be in that position for 3 months, and so on and so forth. At any point where you are no longer qualifying for the level of care that you need, the medical profession, ethically and through their license, they're required to reduce the level of care that's appropriate for you. And that is absolutely true for restrictions on a person's freedom. So if somebody is no longer qualifying for inpatient hospital care, there needs to be somewhere to move them in an outpatient setting or to a step down setting. And Colorado is woefully short of those options. And so if they are there, they are likely already being utilized by someone else. So there are times where we can find, me and my team can find some solutions. I search desperately for those. And I think a lot of what it comes down to is getting to know the system a little bit, having to your best ability to be able to work with the people in that system, and to understand that you are simultaneously in line and coordinating and on the same team as the provider team, and you're kind of adverse to them at the same time, knowing that discharge can happen when it is not in in the entire system's best interest. I guess I could leave it at kind of a broader statement like that. But that said, I think those challenges are something that a lot of people are already familiar with. Well, one thing here that we haven't just touched on real quick is who is the attorney representing. If you are working with criminal counsel, the criminal attorney represents the individual who is facing criminal charges. It's not uncommon that a family member wants to help, and a family member is not the client for a criminal defense attorney, but is more often than not my client. And county attorneys, and the statute's kind of funky, we're not going to go into it, but that there might be a different situation where it's not actually the county attorney's office representing you. Whoever is in that position is representing the people, not the hospital, although they are required to conduct proceedings on behalf of the hospital for and in the interest of the people. So some really esoteric academic lawyer speak kind of stuff happening there that can end up being very frustrating and confusing for people who are merely trying to help.
Well, and let me just add something from the
Sure.
criminal perspective, talking about at the end of the competency statute that any party to the proceeding can initiate a civil mental health hold. That's wrong. The statute says that, but the defense attorney specifically cannot issue any sort of mental health hold, even if I think my client could be certified and is gravely disabled and I'm very concerned about them. It would make me an adverse party to my own client in a civil proceeding, which would instantly disqualify me from representing my client in the criminal case. So that's why a lot of times, as Jonathan said, you will have family members get involved. Sometimes they have some sort of power of attorney or guardianship. Sometimes they don't. But family or the district attorney or the judge is usually the one that has to go to Kate to figure out how the process can get moving, or family could hire Jonathan to initiate that process.
And notwithstanding any conflicts or other ethical concerns. Gotta love lawyers, right?
I remember the first time I ever called Kate to talk about a case, she was like, "You realize you're conflicted on this?" I was like, "Yes, yep, I created conflict. That's why I'm telling you about it."
I wanted to make sure that you, and I apologize, Jen. I just wanted to make sure that you were planning on being a petitioner. Yeah.
I mean, I've had so many attorneys want to be able to do this because, look, as a defense attorney who works in serious mental health cases, sometimes, especially I do a lot of indigent defense, so people who qualify for the public defender. I mean, you have people who are seriously mentally and sometimes seriously physically ill that are just released to the streets, and you want to be able to do something to get them ongoing services, and you can't do this. So, you know, as we said before, I think this part of the statute's trying to do something, but I don't think it's there yet. Yeah. What's the talk in around the county attorney's offices about cases being initiated from criminal cases? Is it happening more and more, or is it still very rare?
You know, I don't think that I'm in a position to talk about any patterns that might be occurring yet. Things are ongoing, and I think maybe at a later date I could have that conversation, but right now I don't feel like I'm prepared to talk about it in any meaningful way, so I apologize.
No, don't worry about it. I mean, it's all kind of starting to get rolling right now.
Yeah.
we're starting to see more dismissals based on the new
Mhm.
competency statute. So
Yeah.
And we're also going to be seeing some changes from the state structural level on how civil mental health system is being managed. I know that there is a blueprint for reform that was released in mid-September, and the intent there is to create a behavioral health authority with the long-term goal of making it its own department. Something Colorado had at some point in the past, and I don't know when. And it kind of got whittled down to a division, and then currently there's an Office of Behavioral Health, and they kind of work in some fashion with the Department of Public Health and Environment. Some facilities are licensed by one, some by another, some by the other. And so streamlining that and avoiding some fragmentation is kind of a first line reformation of our mental health system. And so it's going to take some years to get there. And what we understand as individuals, and certainly Jen and I as representatives of different parties to these cases, is that people are living right now, and they're living with mental illness right now. And so we do what we can. And I think Kate's in the same position as although she represents the people and she conducts the proceeding on behalf of the petitioner, she's still working with people, and it's a best interest concern that she prosecutes. Well, does it bring us to about 50 minutes or so, I think. So those are my thoughts on moving from the incompetent to proceed to mental health. Anyone else?
just a plug for, there are some other videos out on the YouTube channel from my office around terms like insanity and competency evaluation. So if there were any legal terms in here that didn't really make sense, go ahead and reach out and do those. But other than that, Kate, just thank you so much for joining us. We really appreciate having your input here.
Thank you both for having me. I really appreciate the opportunity to speak about the process.